We are speaking to Advocate Shadan Farasat, who is representing Tushar Gandhi in this petition. Supreme Court, of course, has issued notice today to the UP government and to the Muzaffarnagar Superintendent of Police regarding the incident where a minor child was slapped repeatedly by his classmates, allegedly on the instigation of their teacher. Shadan, thank you very much for speaking to India today. First of all, what were the averments? What was the prayer in the petition that was filed before the Supreme Court? And what has the court said today?
Yeah, the prayer was twofold. Firstly, in respect of the proper investigation in respect of the offense, because there have been reports that initially after the incident, there was pressure on the family to settle and not to report or even file an FIR. There was a belated FIR which was filed. And even the FIR which was filed did not have, the applicable provisions of law. They were under very, innocuous kind of sections. Even though under Juvenile Justice Act, actions like this, which is violent act against children, etc., have been specifically penalized with severe sentences and penalties. So those provisions seem to have consciously not been invoked by the police, even though they had belatedly filed an FIR. So the first limb was to have a proper investigation so that this matter is taken to the logical extent. Also, there seems to be a lot of political pressure because of the communities involved, etc. Locally, all political parties seem to be wanting some kind of a settlement or some, force the family to get into some kind of settlement. So that was one aspect, that investigation should happen and without any pressure. The second aspect was that such an incident is, of course, it's quite shocking. It's one of the first incidents of this kind which has come into the public domain. And the idea, therefore, is that we have to nip something like this in the bud, and incidents like this should not be repeated. So that was the second limb of the petition. And to that extent, we were seeking some guidelines in terms of how schools have to function, including involvement of parents of all different, different students from all different diverse backgrounds. And there are mechanisms and provisions already there to some extent, at least in the in different enactments in respect of free and compulsory education. The 2013 Act has, but a lot of those provisions have not actually been operationalized. So a bunch of guidelines we have also sought so that this hopefully becomes the first and last such incident in the country.
So the Supreme Court, of course, has issued notice. They've asked for a report from the Superintendent of Police. What other observations, if any, were given by the court? Any other directions that have been passed by the court?
No, so the court basically has asked the Superintendent of Police to file a detailed report on two aspects. The first aspect is what has happened in the investigation. So that basically that's in effect a direction to the SP to ensure that a proper investigation is done and then update the court about it. And second, that in terms of what are the measures the police has taken to ensure both the safety of the child and of the parents, because there have been clear-cut reports that they are under pressure. And also for the child, I think there were reports that he was quite traumatized by the amount of media itself which was trying to access. I mean, imagine young child who's faced this in school, and then everybody in the media is coming and asking. So that level of trauma also, I mean.
So have you also asked for a restriction on media reporting or something on this matter? I have not specifically
asked for it, but that's something that the court may eventually consider, because these kind of things, even the media has to deal with a certain amount of sensitivity. Everybody should not go and shove a mic into the child's face. So that's an additional point. And I think that's something we will raise. But as of today, the order is to ensure the safety of the child and the parents.
Just one last question. You mentioned provisions of the Juvenile Justice Act which have not been included in the FIR. Are there any specific provisions that you have sought for inclusion in the FIR against the teacher or against any administrators in the area?
Yeah, so we have indicated that there are certain provisions that when a child is in somebody's custody and then the child he's acted on against by somebody who is otherwise in charge of protecting the child. In this case, the teacher is. Then there are provisions in the Juvenile Justice Act, Section 74, etc., the proviso, which provides for punishment up to 5 to 10 years, because obviously you have under law a responsibility to in fact protect the child, right? It's not just a layperson walking on the road. You have a responsibility under law, and then you breach it to further, so it's not just somebody, a regular person doing it. It's somebody with a contrary responsibility breaching it. So it's a more serious offense, and therefore the punishment also is higher. It's up to 10 years.
So you've called for action again under the Juvenile Justice Act only, or also with regard to religious disharmony and other provisions?
The Juvenile Justice Act is in addition to the existing penal law. Now, the existing penal law has general provisions on violence, hurt, etc. They have applied those provisions. Some of them are not even cognizable. Most of them are, very minimal sentences, right? And this happens across the board. Police very often, when they don't want to, they will, register a FIR because they have to, but under provisions which are the most innocuous. So this was the most obvious provision. The proviso of Section 74 in the Juvenile Justice Act is actually something which directly applies to the situation, is meant for a situation like this. And that's the provision they have not even invoked, because the punishment there can go up to 10 years. So that was one of our main pleas. The court has asked them to file a status report on the investigation. So we'll take it forward from that. Yeah.
Thank you very much, Shadan, for speaking to India today. The Supreme Court, of course, has issued notice. Now the hearing will be on the 25th of September, and we'll have to wait and see what the state of UP and the Superintendent of Police of Muzaffarnagar informs the court in the affidavits that they have been directed to file. The matter, of course, now before the Supreme Court.